Thank you, Senator Campbell Rodriguez. Now, I will make brief remarks before we kickstart today's work. I said last week that I can see the finish line and sight of the finish line. It's even more apparent today. At the completion of the committee stage, we will be that much closer to returning to Parliament with the report and propose amendments to the bill from this committee. We have accomplished much due to the diligence of all of you as members, the due diligence of the technical team, whose guidance at this juncture is very, very critical. The Hansard writers, the committee clerk, the IT team, the Houses of Parliament staff, and you, the public. And I must especially commend and thank PBCJ for the exposure that it gives to our work. Our reality has foretold stories where sexual harassment has occurred at the workplace, in learning institutions, and even in accommodations. Cognizant of this, our combined efforts have been geared towards ensuring that our most vulnerable will be able to rely on a legislation that will offer protection and prevention. At our last sitting, we completed the interpretation section of the bill. Today, we will go through the general recommendations made by the various entities and will see to other refinements. Our work in this committee continues to be carried live, as I said, by PBCJ on cable and online, and we express our thanks. But I also want to remind all of you that in making your comments and presentation, that you keep your camera on. If you can keep it on throughout, that will be great. But if not, certainly when you're making your presentation. So I thank you all, and now let's get to work. Ms. Grant?
Morning, Minister. Morning, members.
Good morning. How are you?
I am well. Hope everybody is well.
Very good.
All right. So just go to the general recommendations to include the recommendations that were made the last time we met from Mr. Makulu. So I know that some members had indicated that they wanted time to go through that. So, and those form a part of the general recommendations. So let me go with them as I have them here. So general recommendations on the matrix one, starting first with Norman Manley Law School. They proposed that the bill, since it's aimed at creating a safe environment for all workers, it should extend the context of sexual harassment occurring in other directions. And we had indicated, we had expressed this before, but they expressed it again in the general recommendation section. So not only supervisor to manager or colleague to colleague, but also from worker to supervisor. So, and we had considered that. I don't recall if we had decided on it, but it certainly was discussed. They proposed as well that references to the court throughout the bill be extended to the Supreme Court, and that we contemplate a ceiling on the amount of compensation to be awarded by the tribunal. Jamaica Aid Support for Life suggested that we mandate public education around sexual harassment in multiple spaces. So I will stop there. These are just the general recommendations of Matrix 1.
Thank you, Ms. Grant. Comments, please.
Minister, I have a note here, I don't know, which says that it was something to be researched and brought back to us by the legal team. The first recommendation, I'm not sure, I don't have anything else in my note, but I see here where we had said it was supposed, something was from that was to be researched and brought back to us.
Ms. Grant, do you recall that in your notes?
I don't recall, Minister, so I am consulting my notes just before I respond. If what you are referring to, Senator, is what we commonly refer to as the bottom-up sexual harassment, that's what you're making reference to? From worker, where the worker might harass the supervisor, that's what you're talking about?
Yes, yes.
Okay. We had consulted in previous meetings, section 26, subsection 1, paragraph C of the Sexual Harassment and Domestic Violence Act of the Bahamas, and that section was read as it relates to how they treat with bottom-up harassment, and I have it here in my notes that the technical team had indicated when we brought it that if we decide to put it in, because it's a policy decision, if we decide to put it in, then we would have to treat with bottom-up sexual harassment in a standalone clause. I don't recall any decision being made on it, but that's certainly what the technical team said.
Mm-hmm. Senator Gale?
Chair, I remember us having that discussion. I don't think we had come to a conclusion. I believe what would have happened is that we would have awaited a response from the technical team.
Well, I think the technical team did make the point that it would be a policy decision.
Right.
Right.
Ms. Grant, can you remind us what the Bahamas submission or what the Bahamas legislation had stated?
I'm coming, Senator. I am trying to pick it up.
That's fine.
While you're looking, Mrs. Robinson?
Good morning, Minister.
Good morning, how are you?
I'm very well, thank you.
Yes, in relation to this matter, in terms of it being a position that you would want to look at, what is your take on it?
Thank you, Minister. I think I recall us having the conversation, and a member of the technical team had indicated that even if it is from the bottom up, the person who is in charge is still a worker. And so based on the definition in the legislation, that person who is in charge or is a superior can in fact be harassed by a subordinate. So I think it would be that the decision would be taken based on, whether or not it can be taken, looking at other legislations and how they have treated it. But I think the technical team had started looking at it, and we had said, based on the fact that that person is still a worker, consideration could be made.
So what is your guidance?
My guidance is that it is possible for somebody who is in authority or in charge to be harassed by a subordinate. It can happen.
Mm-hmm. Ms. Grant? Thank you, Mrs. Rock.
You're welcome, Minister.
Yeah.
In fact, Minister, just 1 minute. As soon as I bring it up, I will read the section just to refresh the committee.
Minister, you have Mrs. Brown who might want to make an intervention.
Yes. Go ahead, Mrs. Seeley Brown.
Morning, members. Morning, Chair. If I recall, Chair, what we were basically saying is that even though we had looked at the provisions of the Bahamian draft, if we are to follow the scheme of our bill as it's set out in clause 7, it will just be to add a provision to say that a worker may not sexually harass an employer, because if you look at section 7, we've dealt with employer or supervisor, in subclause 1. We have dealt with worker and co-worker in subclause 3, and we've dealt with prospective employer and the person who is seeking employment. So it will just be to follow the scheme of the bill and not necessarily go into the details that the Bahamian draft would have gone into, to just say that a worker may not sexually harass an employer. But as Ms. Grant quite rightly said, there were some issues as to whether, in fact, we would have needed this provision when there were other avenues available to an employer who is sexually harassed by his worker. And so a policy decision needed to have been taken as to whether you would want to include that particular tier in the provision.
Minister?
Yes, go ahead, Senator Campbell Rodriguez.
Right, let me just apologize in advance. I'm somehow not having the feature to raise my hand, so why I'm physically doing it.
Yes.
In the last discussion, I remember some persons were saying, because I had raised the issue, some persons were saying that it is a simple matter of an employer or a manager firing a subordinate who sexually harasses them. And I was pointing out that the social construct in certain communities in Jamaica would not necessarily facilitate that. Because you're a supervisor or a manager, for example, let us say you work in a wholesale in Spanish Town. Let us just use Spanish Town as a random place because I picked on Kingston the last time. And you fear that in your community, you're going to be seen as a you cause you bunks bread out of Jennifer hand. And as such, as a manager or a supervisor, you may not be willing to fire the person, which is why I thought the clause should speak to it and not just use the term employer, but also supervisor or manager, because it's not always the employer. It's just someone who is above you in the food chain. But I do think and still support the idea that, you know, there needs to be something in clause 4, the same way it is it 4.7, sorry. It is laid out as just mentioned a while ago. I think we need to put something in there, just a line to say a worker shall not sexually harass a supervisor, manager, or employer, whatever the phrasing is. That's my suggestion.
Chair, but if we look at through you subclause 3, it speaks to a worker not sexually harassing a co-worker. So I think that would cover some of what you may be referring to, Senator Rodriguez Campbell, even except for maybe the manager-employer situation. So I'm not sure that we need to speak to the supervisor and if we're doing because that would be worker and co-worker. I'm thinking though of the down up situation where you have the employer, the worker harassing the employer, and I'm saying that is a policy decision that needs to be taken as to how we go forward with it.
Okay. I stand to be guided, but I think the word co-worker is specific to someone who you are lateral with, and does not refer to a boss. That's the Oxford Dictionary definition of co-workers. I don't know if in law it means something else. So co-worker would not suffice as a term to use for a supervisor, manager, or an employer. But I stand to be corrected.
Go ahead, Mrs. Celia Brown.
So, but in that case, Chair, that is a decision that the committee will have to make as to whether you wanted to incorporate it. And if we do, sorry, Chair, not to, and if we're doing it, we may also have to look at the awards in a different light, because it's a down up situation, to see if the awards are suitable enough for an employer or a supervisor who brings a claim against his or her subordinate. Mm-hmm. I'm not saying that they're not, we just have to look at them again to ensure that.
Yes. Thank you, Mrs. Celia Brown. Thank you, Senator Campbell Rodriguez. I'll now recognize MP Brown Burke, then Senator Donna Scott Motley, and then Senator Gale.
Okay, thank you very much. I wanted, Chair, to agree with Senator Campbell Rodriguez in terms of making sure that it is specific. I heard a recommendation that it needs to be a policy decision. And so for now, we will be guided by whatever the policy says. whatever you decide as policy. But I believe it is extremely important. Senator Campbell Rodriguez raised one aspect. The other aspect in terms of where we are situated culturally is I can just imagine a young man making such a claim against a female worker, yeah, who is his subordinate, and the kind of mama man and the kind of other labels that would be attached to him, which would probably prevent him from acting in his own self-interest. I was also wondering too, if including it wouldn't also even just be a kind of protection as well, yeah, for the manager supervisor. And so I would really like to see it expressed in the bill.
Thank you, MP Brownberg. Senator Scott Martley.
You're on mute.
Yeah, Mike, Donna. Mike.
Oh, I'm so sorry. Good morning to all my colleagues. I wanted to support what Senator Campbell Rodriguez said. I believe that it is a real possibility, and the way in which Clause 7 is structured, it delineates the relationships where you would be able to conclude that they're capable of sexual harassment. This is a real situation to which she's alluding. It happens in the workplace. And it was interesting to hear MP Brownberg speak about the young man and so on, because sometimes you will find that the young man who is a worker is extremely bold. Jamaican men tend to be really bold. I can remember, if you will permit me, I'm driving a Mercedes-Benz, and right in Papine, there's a man who is on the roadside. He tells me he's a body man. He's barefooted. He has on, a khaki suit, which you couldn't even recognize as being a particular color. And he tells me that he likes me very much. And when I'm passing back, I must ask for the body man from Papine. So I say this as a very real example to say that in Jamaica, there's a certain sort of confidence which men have, which will not make them recognize any kind of work or social boundaries. And I do believe that if we're doing legislation which is targeting our culture, then it is best to include that example. Even as I say so, I do await Ms. Grant's report as to how Bahamas framed it, to see if it will be of any assistance to us. Thank you, Chair.
Thank you, Senator Scott Martley. Senator Gale?
Thank you, Chair. Let me start from the standpoint that an employee sexual harassing their subordinate or manager is likely to happen. It is likely to happen. And in an employer-employee relationship, there is always that intent to define the scope of permissiveness for the employee. So the employee must know and must be aware as to what rules govern the organization and what is not permissible. And in this case, because it is likely to happen, I would want to suggest that we have a standalone clause that speaks to it. That standalone clause, I believe Mrs. Seeley Brown hinted at it, where it was suggested that just as one clause that said the employee must not harass, whether it is a supervisor or manager or the employer. The other thing is that, Chair, the clause that speaks to a co-worker shall not harass a co-worker may not address it. And let me explain why. That employer might be saying in their mind that I'm not your co-worker.
Absolutely.
I am in fact your manager. And there ought to be that distinction that separates it. And so it is my view that we should have a single clause that represented, that would make that distinction. The other thing, and Mrs. Seeley Brown again made reference to it, it might change the way awards are made. So you may now have an award that the tribunal have to determine against the background, what do we do with this employee who sexually harassed the supervisor or manager? It may very well lead to disciplinary actions being taken against the employee. And so the tribunal now would find itself in a position where it would have to make a particular judgment in that regard. So again, we would have to look at how we treat with the awards and what is the role of the tribunal in this case.
Thank you, Senator Gale. Mrs. I'm sorry, go ahead, Senator Scott Motley, and then I'll take Mrs. Seeley Brown.
I was just actually looking at the award of the tribunal in 34. And one of the things is that if you look at B, it does say that one of the awards that could be contemplated is a declaration that the respondent has engaged in conduct amounting to a contravention under this act in the manner specified in the declaration and shall not repeat or continue the conduct. So if you have a situation where it is the employee who is harassing a manager or supervisor, the tribunal might well be able to conclude that this kind of reprimand would be sufficient in the circumstances, because what I'm hearing is that the whole question of damages and compensation might not be seen as the appropriate award in this instance, Senator Gale. That is what I'm hearing you say.
Well, it is for the tribunal to make a determination which one of these that would apply. The only concern I would have with that, Senator Scott Motley, suppose the complainant in this case, being the employer, is not satisfied with the award that would be made by the tribunal. So the tribunal says, look here, don't do it again. And the complainant is not satisfied. And the complainant in their own mind believe that a stronger measure should have been taken, and then challenges the award of the tribunal.
Then I would take you to B. I would ask you to take a look at 34 B2. I think that there are sufficient clauses there that would give a tribunal an option. But of course, Mrs. Seeley Brown, that is a matter for Mrs. Seeley Brown to advise on.
Thank you, Senator Scott Motley. Thank you, Senator Gale. Mrs. Seeley Brown.
Thank you, Chair. I just wanted to take our minds back to the provision in the Bahamian legislation. Ms. Grant, I found it before you. It's section 26 of—
No, I had found it, Mrs. Seeley Brown, but I was waiting for my turn.
Okay, of the Sexual Offences and Domestic Violence Act. I just want to caution us that sexual harassment under this act is a criminal offense. So because I was looking to see what type of awards they would have, a person who that done up situation would have had redress to. And I realized that, first of all, sexual harassment is a criminal offense. And the provision says, a person who importunes or solicits from a person in a position of authority in any place of employment or any institution, any favor, benefit, or advantage, or the forbearance from the exercise of any right, power, or duty relating to that authority under holding out or promise of sexual favors is guilty of the offense of sexual harassment. And I was saying we can't exactly use this construct because their scheme is different, because one, it's a criminal offense, and they speak of importuning or soliciting sexual favors. It will be easy for us. We can adopt our scheme and incorporate that into the bill. In light of the comment made by Senator Scott Motley, I'm just wondering, I'm just putting it out there, if one of the determinations of the tribunal in a case where it's a down-up situation cannot be a recommendation for termination of employment in a case where the employee is not satisfied with 34B1 or B2. Because you can reinstate where it's terminated when it's down up, and I'm just wondering if we can't have that. If it's up down, if we can't have the reverse if it's down up.
Senator Gale, you wanted to respond to that?
I was still trying to craft it in my mind how best to respond. But again, so this leaves us to the tribunal making the determination. And the power of the tribunal, it rests entirely with the powers of the tribunal. But my only concern is still whether or not if 34B2, a direction that the respondent should perform any reasonable act or course of conduct to redress any loss or damage suffered by the complainant. So if the tribunal makes that award, then I'm just saying what would happen if the complainant is not satisfied?
Are you saying, Senator Gay, that you think that that direction pursuant to 34B2 can be termination of employment?
It could, and it would be an unreasonable tribunal in the case to make that as an award, but that might be the desire of the complainant, and that might have been the submission made by the complainant as for redress. Now, if that is a situation and it leads to a termination of the employment, then another tribunal may have to deal with that particular situation. And then you find yourself in a situation where one tribunal would have made an award for termination to be addressed by another tribunal who has that scope in treating with it. I'm just putting out there, Chair, what are the likelihood of an award being made. And then brings me to another question, whether or not, again, we should contemplate if the award of the tribunal in any instance may be final or binding.
Thank you, Senator Gale. Let's hear Senator Scott Motley on this.
Thank you, Chair. Well, I think I can answer the last question because at 35, it does say that a decision or an award of the tribunal shall be binding on the complainant and the respondent appearing before the tribunal. I believe that in any kind of judicial determination, people might be unhappy about the outcome. Certainly initially, they might have some reservation as to whether they have been treated justly. So it's not that's not an unusual thing, Senator Gale, and you would know in your experience with the IBT and so on. What I want to also point out is that the tribunal does have the power and the authority to make such other award as may be appropriate in relation to the complainant. And I think that clause gives wide power for the tribunal, hearing the evidence, to make a determination as what would be appropriate in the circumstances. So if the termination is the appropriate thing, or if some kind of other disciplinary action is appropriate, or whatever, based on the evidence which they are hearing, I think they also would be able to do so under that provision.
Thank you, Senator Scott Motley. I'm going to ask Ms. Grant, Ms. Georgette Grant, to now make her intervention, make her comments.
Thank you, Chair. I have been trying to follow the discussion, but I do agree.
Camera on, please.
Oh, sorry about that.
Senator Scott Motley, your hand is still up.
I do agree, Chair, that the making such other awards as the tribunal sees fit is something that could take care of, if we decide to include the bottom-up harassment, is something that could be used for the tribunal, depending on what as they listen to the issues in that particular case, for them to come up with an appropriate award. So we have to put it in a standalone clause, yes, because it's not addressed anywhere else in the legislation if we decide to put it in. Even though I went back to the policy while we were discussing, it was not originally contemplated in the policy. But things that are not originally contemplated in the policy, if the policy has such an ambit that it can allow for insertion, and I found, I don't think it's something that would take us so outside of the ambit of what the policy had originally envisioned. And so if we put it in a standalone clause, then certainly failing what Mrs. Seeley Brown had suggested to put in that the employer can terminate the employee's engagement with an organization, that any other award that the tribunal sees which is appropriate in my view. Thank you, Chair.
Thank you, Ms. Grant. I will ask Mrs. Robinson to make her comment, and then members, I think we should make a decision here. So I want you to just think about it. In the meantime, I think we're getting somewhere. Mrs. Robinson?
Thank you, Minister. I do believe that I've listened to all of the conversations, the comments, the recommendations, and I do believe that there's virtue in taking note of what has been said. And so I will take advice from a technical team in terms of the final decision. I do believe that there is a way of doing it so that all persons who need to have this section of it, whether it's going to be a standalone clause or it's going to be subsumed, I believe that this is something we can get from the technical team.
Thank you, Mrs. Robinson.
You are most welcome, Minister.
All right. I will take comments from members now, and then I will go to the technical team. You know, to provide some guidance, as Ms. Grant said, though it was not originally contemplated, we could now consider there could be a standalone clause, etc., etc. What we need to determine now, with the guidance of the technical team, is how do we insert this? And I'm going to ask members to just indicate what is their position at this point. Senator Gale, take you first.
Thank you, Chair. My position would be to have a standalone clause that makes representation to it.
Thank you. Senator Campbell Rodriguez, your comment?
Yes, I had raised this issue and I still support a standalone clause. And we cannot say we can't say employer. We need to make sure we say supervisor or manager so that we cover all bases. And it can't be co-workers.
Thank you, Senator Brownberg.
I also support a standalone clause as well, just to make sure that it is explicit. And I agree with Senator Campbell Rodriguez that it has to be clear in terms of the relationship. That is not a co-worker and is not necessarily the employer either. So it covers the supervision in between.
Thank you, MP Brownberg. Senator Scott Motley, you wish to make a comment? MP?
Just to endorse what has been said previously, that a standalone clause would be the most appropriate way to deal with it, Minister.
Thank you. Other members, you wish to make comments, or you're pretty well on the same page as those members who have spoken?
MP Crawford here. I am on the same page. Can't turn on the camera just yet. I'm in the constituency. The connection is a bit bad.
Okay. Okay. Thank you. So,
Minister, I also want to add support for the recommendation, making it explicitly clear in the bill.
Thank you, Senator Morris.
Chairman Fraser Binns here, and I too agree with the members that it should be a standalone provision, making it very clear and to prevent any ambiguity.
Okay, great. And I know MP Whittle is also on board. I am now going to ask the Solicitor General to make a comment, and then we take it. SG, you there? Yes.
Yes, Minister, I have no comment. Thank you very much for the opportunity.
Okay. All right. So, Mrs. Seeley Brown, it's now in your hands.
Yes, Chair. As I indicated earlier, it will just be to incorporate it as a subclause of clause 7 of the bill.
Okay, so that is the...
So that's the scheme that we, just to bring it under the scheme of the current provisions of the bill. So it'll just be a phrase to say something like, a worker shall not sexually harass a supervisor or employer. I'm not drafting, but language to that effect.
Yes. Okay, thank you. So we have settled that matter. Ms. Grant, could you continue, please? Thank you.
Sorry, Chair, just to, sorry to interject like this, just to point out that the Chambers had a few matters that we were going to report on. So I'm not sure when you want to give us that opportunity, if it's no or are they late going to the end of the meeting? I'm not sure, but I'm just bringing it to attention.
It's going to be very soon, SG. We're calling on you very soon.
Okay, all right.
Right. Ms. Grant, you where were you on your presentation? Just have to catch up again.
Okay, Chair. Just before I continue, Mrs. Seeley Brown, we'd have to make the necessary cross-reference to. I'm looking through. We'd have to make the necessary cross-reference to in relation to where that is done. So I'll look through the sections. I think maybe 25, 13, and those other sections. So we'll just do the necessary cross-referencing.
Agreed. Okay. Thank you. Thank you, Ms. Brown.
You're welcome.
Okay.
One of the other things that they said, Chair, the proposal that the references throughout the bill as it relates to court should be the Supreme Court. I don't agree with that. And that we contemplate a ceiling on the amount of compensation to be awarded by the tribunal.
No, I think members?
Chair, let me deal with this thing about the cap of an award, because I've heard it here, and there's also submissions or concerns being raised by the private sector in terms of a tribunal capping an award. I'm always of the view that the tribunal must make its own rules and determination and be given that scope. When an IDT or when a tribunal is to determine the amount of a cap, on the one hand, then there are those of us who might say, on the other hand, is there a ground level? Is there a minimum for an award to be made? And what exactly expressed is that minimum? So you ask for a cap or a ceiling, but there are those that might say that amount that you have awarded is too low or continues to be too low. And so that's the danger that you have. The other thing when you establish a cap is that the value of that cap is likely to change in time. And is it fair to those who should benefit from the award that you are capped with an amount when the value would have changed within the period to which we would be reviewing this piece of legislation? And so I'm not in favor of establishing any cap for an award. I would leave it to the tribunal to make that determination.
Good. Thank you, Senator Gale. I see Senator Brownberg, you want, MP Brownberg, you wanted to make a comment?
You know, just to add that I definitely do not believe in placing a cap. At some point, depending on the cap, it means that individuals will determine whether or not it is worth the risk in terms of what the cap is. I believe that we have given the tribunal wide-ranging powers. All of it is not necessarily financial, what financial is included. And I think that we should ensure that we have individuals who are qualified and competent to make a decision based on the merit of the case as to if there's a financial reward awarded or what that cap should be. I definitely don't support putting a cap in.
Good. Thank you. So I can say we all agreed. No cap.
Agreed, Minister. Just one more thing I'm seeing in my notes from that same section, if you may permit me. I have a note here that we had also raised the question, or I should, let me change that. The question was also raised as to board members. How will, and I don't think we came to a conclusion, how does the bill address board members? Because as written now, could it fit somewhere in that same, where is it that is handled? Because you're not technically co-workers.
That same standalone clause.
So yeah, just to bring it back to the fore, that the issue of board members needs to be considered with that clause or with another standalone clause by itself.
Okay. Ms. Grant? Mr. Ritter, you wanted to make a comment? MP Ritter? Okay, Ms. Grant?
We continue then, Chair.
Yes, well, I think Senator Campbell Rodriguez needed some clarification.
On the board members bit?
Yes.
You're saying, Senator, that you would want it included?
Yes, it was something that we had started discussing, but we hadn't come to a final conclusion, just as the matter before about superiors and subordinates. So I just want to know if, ensure that we also consider a subclause or a clause for board members.
Okay, I'd have to well, the drafting is one thing, but are the members agree that that is what we'd want included, that board, in terms of board members being covered? Because that was not, again, originally contemplated in the part. So it is, do the members agree that this is how they want it to be? And if so, then you didn't see how the drafting goes.
Senator Campbell Rodriguez, exactly what are you contemplating? What exactly?
I'm just thinking if you have a board and someone else had raised it earlier, and I just had the note that we hadn't reached a final decision. If you have a board and someone on the board sexual harasses someone else who sits on the board, how would that be addressed? Would it just be treated like any person sexually harassing another person? I don't think it's covered. And if it is covered, then, I will stand down. But I'm just thinking that it should be addressed as an issue as well, because it is workplace technically.
Senator, you want to comment on this? I see your hand up.
Are you speaking to me, Madam Chair?
I saw your
Were you
hand.
calling? Yes, I must say that I have some reservations about that. I think that we must be careful at all times to go back to the intention of the legislation. And I think that to take it as board member to board member, which is what I call equal relationships, I think it's not what was intended. I think we looked at the vertical and the horizontal, and now we were looking at. But I think that somehow this takes it a little bit too far. And I was actually reading a case last night. I wish I could have remembered exactly what the name, but it was a judgment of Justice Sykes, who pointed out, in fact, the case involved was brought by Erica Allen against somebody who is harassing her, constantly teaching her. And the case was brought in private nuisance, and Justice Sykes said it could not prevail. It did not meet that standard, but he nonetheless made it clear that there is a tort of harassment which exists. So that I think that we need to focus this piece of legislation in a very clear way. And I think that there are other ways in which somebody who is harassed would have some recourse. I don't think that this bill is a bill that should deal with it.
Thank you, Senator. I see MP Morrison's hand up. Go ahead, MP Terence Morrison. MP Morrison? Okay. All right. So at this point, I would indicate.
Minister, I just like to ask some questions and just for clarification, because I understand what Senator Scott Motley is saying in terms of board members peer-to-peer. I was also wondering though, if that would mean that if there was a case of a board member with a staff member, for example, if that is adequately covered where we are, or if that would merit the same treatment from the perspective, from Donna's perspective, just for clarity.
Ms. Grant?
I'm sorry, MP Bromberg. I got lost in translation there.
No, very clear. I was just asking. I understood what Senator Scott Motley was saying about a board member and a peer-to-peer meeting, board member to board member, and that not being the subject of the bill. But I was also wondering if we had a board member. There's some board members who are very active in the company, very active. And they're there all the time doing this, doing that, and all the rest of it. And they come in contact with employees. And I'm just wondering if the bill as currently drafted would cover that, or are we suggesting that there would be no need to do that? I just wanted some clarity.
Okay, well,
so the question for you would be whether or not it currently covers it. And what I was asking Donna is whether or not she saw that as being different from board member to board member. So it really is a two-part question.
Member sexually harassing a staff member.
Right. Yeah.
But as it is currently crafted, is not specifically referenced in the legislation, but it's not specifically referenced in the legislation. But if so the strictest answer is no, it's not specifically referenced. And that would be a one-off situation in terms of a board member interacting with staff, and it would not be an everyday occurrence in a lot of organizations. So it's not something that is covered. However, I remember in meetings past, we raised the issue of third parties and including the third parties in the bill. If we could take it from that aspect, but my short answer on it, MP Brownberg, is that it doesn't need to be included. I think we need to widen the bill too much is to provide it like a ship without a compass. And so I think we need to stick to the fundamentals, as it were, taking in other valid suggestions, but to include board members, I think this bill would not be the appropriate forum for such inclusion.
Thank you, Ms. Grant. I will recognize Minister Johnson Smith, then MP Carencia Marson, and then Solicitor General. So could you go ahead, Minister Johnson Smith?
Morning, Chair, and morning, colleagues. And apologies for having been late this morning. My first meeting ran late. On this, I wondered whether Senator Scott Motley could share a bit more about her thinking. Sorry, I think somebody else is.
I'm sorry, go ahead, Minister Smith, go ahead. Minister Johnson Smith, go ahead, please.
Thanks, Chair. Yes, I was asking whether Senator Scott Motley could possibly share a bit more about her thoughts on this expansion, or what is viewed as an expansion. And I ask because, having discussed that co-workers are included, notwithstanding their parity in terms of power status, power dynamic, we've also included bottom-up, so that someone can harass someone with more authority than they have. And the meeting has also, if I recall correctly, been minded to include third parties, meaning persons who are being seen in the context of being a client or a patient, or in some other capacity that's not specific to an employer-employee situation. And I wondered, in that context, what would make board members so unique that they wouldn't be appropriate for inclusion in this bill, both in the context of their ability to make a work environment hostile, or what's the other phrase that they use, that we use in the bill, intimidating, offensive, or hostile. Because certainly if I am sitting with a colleague in a board meeting, it is still a work environment. And whether they if they are inappropriate, whether in person or virtually, it's still a work environment, which is part of our discussion, our previous discussion. So whether it is board member to board member or board member to employee, I'm not sure why, having gone through all the other discussions that we've had, why we wouldn't include board members in the bill at this time.
Well, may I respond?
Minister Johnson Smith, I'm going to ask you when you respond to put your camera on. Thank you. Go ahead, Senator Scott Motley.
I don't have a strong view about it, Senator Johnson Smith. But at the same time, I have to be mindful of the expansion of the categories, which would lead now one to say, what about a chairman with a board member? There is no end to the power dynamics which we have, no end to the configurations which we might have. And I can see from the example which Senator Johnson Smith has given just how it could happen and also the effect it could have based on the fact that she describes the board meetings as a work environment. I do have a reservation about the continued expansion of the categories. I believe that if the technical team were to be of the view that the third-party proposal that we made could take care of situations which we have not specifically addressed and indeed not yet contemplated, then that is the way that we should go. But what, as I said, and I am repeating myself, what therefore then would now preclude us from saying a chairman with a board member? It's just things that we need to think about while we are progressing.
I agree.
Thank you, Senator Scott Motley.
Thank you, Chair. Sorry, Chair. Sorry, Chair. Just as it was a response.
On Mr. Johnson Smith.
Sorry, my mouse dexterity is off this morning. But thank you for having allowed the response. And Senator Scott Motley knows that I share her view that we have to be careful about how we treat with the scope of the bill and ensure that it is, that it has a compass, it has a clear scheme, and the parameters are understood so that we can have the broadest buy-in and understanding in its rollout and its effective implementation. Agree 100% in principle. But on this particular point, I unfortunately, however, I also think, well, wouldn't we want to protect a board member from harassment by the chair as well? Because it is a work environment. In fact, it's a clear work environment. And so I share the hesitance or the concern about an ever-moving goalpost. But part of that, I think, has to do with the language. So I agree with you that we should get some guidance from the technical team in terms of how language can be used that is sufficiently flexible for the uncontemplated, but for the appropriate inclusion. So I agree with you entirely on that. I'm not suggesting that we keep including new terminology and new categories, because I think that's going to end up with its own problems as well. So I share with you the view that some language that has sufficient flexibility for the third party that may well include this type of category as well. But I do think that it would be appropriate to protect a board member from a chair and a colleague board member. I think it's within contemplation of the scheme that we've been discussing so far. But thank you, Madam Chair.
Yes, thank you, Minister Johnson Smith. So we're speaking of protecting a board member from being harassed by the chair or vice versa. We're protecting a staff member being harassed by the chair or a board member. And we could continue and go on. So I'm going to ask Solicitor General to go ahead and make her comment at this point, and then I will recognize
Madam. Okay.
And then Mrs. Celia Brown, and then Erica Simon. So go ahead, Solicitor General.
Okay, thank you so much, Chair. And I'm hoping that maybe my intervention will bring some clarity. It's a dangerous C word that I've just dropped out there, but clarity is something that we are always seeking to find, and sometimes it's quite elusive. I'm not quite in a that the situation is not contemplated in the bill. So if you allow me, please just take you back through how I see the scheme of the bill. So I know a lot of persons have focused on what's in part 3 of the bill that speaks of, the heading is forms of sexual harassment and related prohibited conduct, where it first says the employer or a supervisor shall not sexually harass a worker, and then it speaks about the institutions and accommodations. However, that is not the only protection that is out there. That's not the only offense that can be committed under the bill, and the only protections that you can get if you approach the tribunal. You have to look at clause 3.1. Clause 3.1 places a duty. And what is that duty? The duty is for the employer to make sure that workers are not sexually harassed in the course of their employment. It's wide. It doesn't say that they mustn't be harassed by a coworker. It doesn't say they must not be harassed by a supervisor. It says that they must work in an environment that's free from sexual harassment. Now, does that have teeth? If you go to clause 25, you can see that you can make a complaint if you think that there has been a failure of the employer to act under clause 3. It has teeth. It's not just that the bill says there is this duty. The duty is an enforceable duty. The employer can be taken before the tribunal for failure to comply with this duty. So I'm not sure that the situation that is contemplated is not addressed in the bill. I would actually say it is addressed in the bill. I would say it's addressed from clause 3.1 in the bill. And again, when you go back to the awards, perhaps maybe the issue is what sort of award that the tribunal can make. And I think perhaps that is where the focus of the committee can be directed to perhaps maybe tweak the awards to ensure that it would address this type of situation.
If you'll allow me, as I can't raise my hand, the feature isn't working, Minister.
Senator Canberra Rodriguez will come back to you.
Okay.
But I wanted to recognize MP Brownberg and then Mrs. Seeley Brown.
Thank you very much. Thank you very much, Madam Chair. And I'm pleased that the surgeon actually went before I did, because it eased my concern and made me much more comfortable. And, you know, I kind of want to draw attention to even just the discussion we've been having. And I agree that we don't want it to be so broad that it has, you know, that the direction isn't clear and all of that. But I also believe that a bill of this magnitude should look at those areas that could possibly arise, you know, those situations that could possibly arise. And I mean, I've looked at part 2, 3.1 and 2, and then at 25. And so I am okay with that. I wanted though, Minister, to just say that when we use words, valid amendments, we need to be very careful what that suggests about the opinions that people place on the table, yeah? And certainly as we look at this, we have to just remember how loaded those words are. We also want to make sure that we really do make the environment, yeah, we cover the possibilities that could arise in the environment. So, I mean, I'm grateful for the surgeon's intervention that has placed my mind at ease.
Thank you, MP Brownberg. I will ask Mrs. Seeley Brown to make her comments now.
Thank you, Chair. Yes, Chair, I'm just agreeing and adding to what Mrs. Aldred is saying. That clause 3.1 will in fact cover that situation. The other thing is, Chair, when you look at clause 4, it speaks to the whole issue of a policy statement being provided or being drafted by an employer. We can even, when we are crafting it for the schedule, Chair, for the comfort of members who think about these different scenarios, we can even incorporate things in that policy statement in the schedule, Chair, to deal with aspects with board members and that sort of thing, to make it a little clearer. But I think if we keep on expanding it the way that we are discussing or proposing, we may end up with some issues down the road in that regard. And I think 3.1 covers it, and you actually have redress under, I think it's clause 24 or 25 of the bill.
Thank you, Mrs. Celia Brown. Erica, Simon?
Yes, morning. I just wanted to add that my reading of it, apart from the avenue under clause 3, my reading of it is that the board could be considered the employer, and maybe it's that we might need to revise the definition of employer, but I don't think any further provision needs to be made for the board under the bill.
Thank you so much. I will now take Minister Johnson Smith, then MP Carencia Morrison, and then Solicitor General.
I think Senator Campbell Rodriguez was before me on the floor, Chair. So,
oh, yes. Yes, go ahead, Senator Campbell Rodriguez. Sorry about that.
Thank you, ministers. I disagree that 3 covers it, because under the common grant rule, which I think also applies here in Jamaica, unless I'm wrong, I'm not an attorney, board members are not employees. And as such, it would not cover them. Board members are not, unless our laws here are different. They're not, so we can't use 3.1 to cover them because it says harassed in the course of their employment. They're more consultants, they're not employees, so it would not be covered under 3. And I just want to say I disagree that to expand to include board members is wrong, because this bill, unless someone can tell me where else sexual harassment of board members should go, under which act it would better fit, then I stand with the position that this is the best place for it. And if we have to expand a little bit, it ensures that we get it right. I'm not sure it does any harm at all. So I just need clarity on if the laws in Jamaica are different, where board members are considered employees, because generally they are not.
So Chair, if you will just allow me to just clarify the comment. Board members are not employees, but I was saying it in the context of a board member harassing an employee, and the fact that the workplace for the employee is supposed to be an environment that is free from sexual harassment. So from that perspective, because I heard examples given of board members sexually harassing employees, and I'm saying from the perspective of the employee, it would be addressed in clause 3.1. That's all I was saying.
Okay, understood, but it doesn't cover the areas of board member to board member or of the other dynamics that would include board. But thanks for the clarification.
Right, so it would cover board member to employee. It would not cover board member to board member, because that was not the remit of the bill, and that was not the policy of the bill. The policy of the bill was to cover the workplace, accommodations, and institutions. So that is the reason it was crafted in this way, as far as I can tell. And I mean, Minister, you have your technical team from the ministry to more expand on the policy. I know that we have also looked elsewhere and we have not found this expansion. Not to say that Jamaica can't be a maverick, which we are from time to time, but this was also not something we saw elsewhere. So usually you look to see what the remit of the policy is, and then it is then given effect in the legislation. And then the guidance we got from other jurisdictions is also reflected here, and we did not see that expansion anywhere else.
Thank you, SG. I will ask Minister Johnson Smith to make her comments, and then MP Morrison. Please go ahead, Minister Johnson Smith.
Thank you, Chair. And thank you, SG, as well, for your intervention. I have to say that I like Senator Campbell Rodriguez, can't think.
Minister, camera on, thank you.
Oh, sorry, thank you. I like Senator Campbell Rodriguez, can't think of another place where this would be. And I also don't think that it is beyond contemplation that board members would be in here because in fact their engagement is in the context of work. They are together in the context of a work environment. So I had in fact been looking to see whether the language was in fact broad enough to contemplate it, recognizing that yes, 3 provides for the employer. And in fact, when you had spoken, SG, you didn't necessarily make the distinction between board member and employee as opposed to intra-board or chair and board. So I was looking at it and saying, but okay, if the employer is, let's say, PCJ, and the board is contracted to serve in an advisory capacity or whatever other governance capacity, but contracted because the board wouldn't be the employer, the company would be the employer. So a public company would have a duty to create an environment, but only for its employees, not for its contracted persons. And therefore, I'm also wondering, looking at that breakdown, you know, you would be, if you're an employee contracted, you could still be a co-worker because a co-worker doesn't say that you have to be, a worker doesn't say that you have to be employed under particular terms. You can be contracted, a person engaged under a contract for services. So, and that brought me back to sort of to wonder whether a board member could in fact fit in the category of worker, or if it was in contemplation, but now as we sort of unpack and unpeel the intentions behind the bill and the actual scope of the words and how we intend them to be interpreted, is it that a board member could come in under definition, under C in the definition of worker, a board member? Or is it that we are saying that they should not be contemplated? Because I can't think of how else they would be addressed, given that they are working and they are there under a contract for services, whether as chair or as board members, they are contracted by a company in order to provide the services for which they are contracted, whether in public or private sector. So I'm not convinced that it is beyond the scope of policy for them to be addressed, but I do believe that there would need to be some further thought given to whether they are in fact covered, whether they should be and whether they are in fact. I think they should be, but clearly everyone is not of that view. I'm not sure what makes board members so invulnerable that we wouldn't want them protected by this act, because they are there by virtue of work and for no other reason. So I won't delay the point any further, Madam Chair, but those are my thoughts, and I think that the issue is worthy of a little bit more contemplation, even if 3 does take us some way down the pitch, it doesn't take us all the way.
What about the definition H and I, volunteer or person, a person of class prescribed by the minister?
HRI on the which section?
Under the definition of worker, but
Chair,
I think.
well, if I could though,
Yes, please, through the chair.
Sorry, Chair, sorry, Minister. It's just that I would think it is better if the committee decides that they want the bill to be expanded to address the conduct of board members, then it should be specifically listed, and a board member wouldn't be a volunteer. I wouldn't class them as volunteers either.
And there wouldn't be a person engaged under contract for services?
Not all of them. I don't think all of them would fit in because of you have different different means of engaging board members. The different statutes are all not quite identical. So I'm not sure I would also want to rely on that. And then to rely on it means that there would have to be consultation. But to me, if it is that the committees agreed on this, then it should be just specifically listed as a category, if this is where the committee is going.
Thank you, SG. We will come back to that. Let me hear from MP Morrison, and then I'll come back to members for us to discuss if we want to include this specifically. And I will take comments from members in order for us to make that decision. I will also ask Mrs. Robinson to be on standby to make her comment as well, and Ms. Grant. MP Morrison, please. MP Corencia Morrison, your hand is up and you wanted to make a comment. Please go ahead.
Chair, her mic is open, but we're not hearing her.
I did call and ask her and she said yes. Maybe she's having some technical difficulties, so we will open the discussion to members in relation to, do we want to consider and include in the bill board members. I'll ask Ms. Grant. I saw her hand up earlier. She may want to make a comment now, and to ask members to indicate their position. Go ahead, Ms. Grant.
Yes, Minister, my hand was up earlier to say what the SG had said previously. So that's why I lowered it. But on this point, I agree with the SG that if it is the will and pleasure of the committee that it be included, then it needs to be specifically listed.
All right, thank you. I will ask, Senator Gale has been very quiet.
Normally, Chair and members, when I'm quiet, I'm just listening to the comments. But in thinking of it, before the SG had expressed what the bill looks like, I was looking at 3, the duty to ensure environment free of sexual harassment, and whether or not in the first instance we can have an expansion of that to capture outside of the employee, but to deal with what is likely to happen, what may happen in terms of the board member. And the fact that the matter has been raised in the protection of board members, whether it's board member to board member, chair to board member, or board member to chair, it means we can't leave it alone. What we have to clarify is whether or not, under the definition of the worker, if it can be included there, or we have a separate area that would seek to represent it. But I believe that in the likelihood that it can happen, and the fact that it has been raised, I believe attention needs to be given to it for its inclusion somewhere, so that those individuals are protected. And that would be my submission, Chair.
Thank you, Senator Gale. I recognize Senator Fraser-Binns.
You're muted.
Senator Fraser-Binns, you don't want me to hear you.
Senator Gale, good morning. How are you? I've been listening to the conversation, Minister, and I think that there should be some provision that covers board members. I was actually trying to recall the exact incident, but many years ago, I remember a story, in fact, in real life, of a worker or some workers who were harassed by a board member. And the matter was dealt with. and the board member was asked to leave serving on the board. But I do also recall that sometime after that, the board member was placed on another board. And so just listening to the conversation, I recall the incident and I remember how affected the workers were. And I think that if we can carve out something to protect workers, because it does happen, then I believe that we would have gone a far way in achieving the objective here. The other thing as well is I wondered, just following up on what the Solicitor General said, looking at part 3 and the difference in views, it says an employer shall make every reasonable effort. And then I look back at the definition of an employer, and it says an employer means a person who engages in any form of worker. And I wondered whether that definition was not wide enough to cover board members. And I know it only deals primarily with the board members and the workers or the employee as opposed to board members. But I wondered whether that was wide enough to cover the situation. I will be guided by the technical team. Thank you, Minister.
Thank you. Thank you, Mrs. Fraser-Binns. I'll take Senator Scott Motley now. Thank you.
Thank you, Chair. When I made my intervention, I sought the guidance of the technical team as to whether there was any provision which would presently deal with this situation. Having listened very closely and having in the meantime looked back at the bill, I am satisfied that there is none. There's not a board member, it's not a volunteer. I don't think it's covered by also it's not a worker in the strictest sense of the word. And so I'm of the view, having listened very, very carefully to everybody and to all the interventions, that the matter should be addressed. And it must be addressed perhaps in the definition section. But I do support the recommendation.
Thank you, Senator Scott Motley. I will take Senator Longmore, then MP Brown-Burke.
Thank you, Chair. And my apologies again for being late. I recently just got the Zoom link. I was listening to try and keep up with the conversation. And in terms of the inclusion and the explicit expression around board membership and the issue of sexual harassment, I think that it should be explicitly stated, considering again that this is a significant issue within our culture and the precedents that we are trying to set in the passing of this bill. It would go a far way to recognize and to demonstrate that we are having a zero tolerance approach, and to specifically state that in the bill, I think would be significant.
Senator Longmore.
Yeah.
Yes, you want to continue?
No, it's okay. I got a call coming in. Thank you.
All right, thank you so much. I just have a comment here. MP Witter was having some technical difficulties, but I'm going to read his comment to you. He says, I believe that a boardroom is an institution, and any person who sits on a particular board is definitely a part of that workforce and are subjected to any laws or regulation of that organization. There is no board that is independent. Those are the comments from Member of Parliament, Frank Whittle. I will now recognize the Solicitor General, who has had her hand up. Please go ahead, SG.
Oh, thank you, Chair. Thank you. Just to respond to Senator Fraser-Binns with the definition of employer, because it still links back to someone who engages a worker. If you look at some of the statutes where we establish a body corporate and a board, sometimes the boards are not the ones to hire staff. Sometimes they are, but sometimes they are not. So again, to rely on that provision would perhaps exclude some, which is again the reason I was suggesting if the committee is minded, it would be better to explicitly state the board members and the context. Putting it in the definition of work at least would put the context that, because it's not just any board member, it would be in the context of the specific work environment.
Thank you, SG. MP Bromberg?
Thank you, Chairman. I mean, I'm laughing only because I was extremely concerned when we started the conversation that we thought that it should not have been included. And having not wanted to extend the scope of the bill beyond its original intent and what we have already changed, I listened and I took guidance. I was concerned, though, that even those of us who probably would be most familiar with the bill seem to have been unsure as to whether it's covered or not covered. So put it this way, I am saying that it needs to be covered. And I am going to be guided by the technical team in terms of how to do that. I cannot foresee a situation where the board is not seen as part of the establishment, the employment, right? And that they are outside of the statutes here. I really can't. And I can't because I have seen enough boards at work to know that these things happen. Yeah. And so I just want to make sure it's covered. It seems from what is now being said that it is not sufficiently covered, and that if we want to make sure it is there, then that it has to be specifically identified and named. And I'm honest, I believe that it is a board member, I believe, should feel comfortable having been asked to sit on a board and to contribute in that kind of a way that they're not subject to harassment from anyone, any other member of the board, chairman or any other member. I also believe that a worker, and I mean, it's amazing sometimes the things that happen. And I would want to make sure a member of staff who has to interface with the board on a regular basis, and to me, no matter how often, also feels as if they also have recourse if they are being sexually harassed. And I believe that for me is the bottom line.
Thank you, MP. I will recognize the Solicitor General, then MP Crawford and MP Daly.
Minister, sorry to interrupt, but Karen says on the phone, and I've been trying to get someone to add her back in the meeting. She's asking if she can speak on speakerphone for her turn because she can't get back in the meeting. No one is letting her in.
Right, we'll sort her out.
Okay, thank you.
Please. Sorry, I didn't need to speak, Minister. My hand just needed to be lowered. I apologize.
Okay, no problem. MP Crawford?
Okay, just to say without repeating what my colleagues have said, it's difficult because I'm traveling in the constituency. So just to quickly say without losing time to repeat what my colleagues have said, is that if the definition cannot accommodate the interactions between board members or board members and members of staff in an establishment, we should explicitly state it somewhere else in the bill, because the situation is real. Having sat on a board before, sometimes outside of a board meeting, you have no other interactions with member of that board. And I'm speaking about board members to board members. So if that is not covered in the bill, and there's an issue or there's a case of a sexual harassment, I don't know where else the person who is harassed could go for redress. And of course, if it is board member and a member of staff in an establishment, there needs to be an avenue for that as well. So if it cannot be accommodated in the definition, I believe it should be explicitly stated somewhere in the bill. Thank you.
MP Crawford, MP Daly.
Minister, morning. Morning.
It's still morning.
Yes. I personally believe, and I was a little surprised because, you know, I did not go through in its entirety the bill in terms of, you know, page by page and stage by stage. But I was a little surprised not knowing that, not recognizing that it was not part of the bill. The board is part of any organization. And therefore, it is very important that we protect the board, protect the members, and to ensure that we have an holistic approach, especially when we are dealing with matters of this nature that is so delicate. And therefore, I am in agreement for us to be able to add it. I do not, if it want to be done separately, as they are really the managers, the persons who do the oversight and so forth, but I believe it's supposed to be added.
Thank you, MP Daly. I will now ask MP Carencia Morrison.
I hope you're hearing me now, Chair.
Yes, I can hear you. Can you put your on, or
thank you so much. Thank you so much, Chair.
Can you camera
not quite yet, Chair.
Okay, fine. You can go ahead. You can
All right.
go.
Board member to board member, Chair, it strikes me as the work environment, and I take the caution raised by Senator Rodriguez because it is, I see how it is happening. At first, when she mentioned it, I thought that that was stretching it too far, right? But when the scenario was actually laid out, I'm seeing how exactly it can be possible. I don't think that our struggle, though, is to attempt to contain the range of possibilities that exist. But because all scenarios cannot be scripted, right? Because that is what will pose a challenge here if we are to include every likelihood and every probability. Because all these scenarios cannot be scripted, I'm of the view that we have to continuously touch base with the definitions to ensure that the definitions, you know, that they are strong, that they are robust, that the definition can sustain all the situations that may arise, and that the definition is capable of encircling most of the probabilities that will come before us. That's my thought.
Thank you, MP Morrison. Thank you so much. Senator Scott Martley, please go ahead.
Thank you, Minister. I have a concern in the sense that we have been having these deliberations over many months, and they have all been intense and everybody has participated. Today, April 6th, is the first time that through the intervention of Senator Campbell Rodriguez that we are contemplating the board members and chairman of the board. I want to ask Ms. Grant or the Solicitor General if there is a provision which could be made, which could encompass or deal with any situations which we have not yet contemplated. Because as I am listening and I respectfully listening to what everybody has said, and I have shifted my own view, I do recognize that we here sitting cannot possibly contemplate all the different circumstances in which sexual harassment might arise. And that is my concern at this stage. So that is where I'm seeking some guidance as to, if we have not thought about it, if it is a category that did not occur to us, how can we anticipate it by way of a general clause or something like that? Thank you, Chair.
Thank you, Senator Scott Martley. I'm going to ask, just before Ms. Grant and the Solicitor General make their comments as requested by Senator Scott Martley, I'm going to ask Mrs. Robinson from the Bureau of Gender Affairs to comment. Go ahead, Mrs. Rob.
Thank you, Minister. So given the fact that board members are critical to the operations in terms of oversight and governance of organizations which they serve. I believe that provision could be made for them to be included in that list that we have on page 4, that on the worker, it could be, let us say, J, that would allow, because they are in fact a part of the organization. And based on the definition of sexual harassment, it says making the means of making of any unwelcome sexual advance towards a person by another person, and board members are persons. And so I believe that provision could be made for them in that list that would allow for them to be covered, because it speaks to, it goes further to speak to worker. So if it is that we're going to include them, they would have to be listed. That's what I'm thinking, under that list. That's how I think it could work. I am guided by the technical team and by Solgen, but that's where my headspace is. Thank you, Minister.
Thank you, Mrs. Robb. Ms. Grant?
Minister, I'm still thinking about it. I heard what Senator Scott Motley said. I am still thinking about the catch-all approach, which is essentially what we are saying here. Because we can't plan for every conceivable instance, how do we cater for them when they do arise? And as I said, I'm still thinking about it, but my immediate response would be, because it is such a nuanced issue, and no one act of sexual harassment can translate to somebody else's situation. I don't foresee a situation where we will be able to include a catch-all provision that will effectively cater for every conceivable instance that sexual harassment could occur. But I'm still looking into it. I see the soldiering on. That's what I will say for now.
Okay, thank you. I will recognize Senator Longmore and Solicitor General.
Thank you, Chair. And I should let you know that I have pulled over. I'm en route to somewhere and I've pulled over. I'm not driving and multitasking that much. Maybe I just want to make it clear that I personally think that we may have it covered, because I think there is some coverage in terms of the worker definition and the execution of tasks assigned. But my personal thing is that for the zero tolerance effect of being communicated, that it is we're not tolerating it at any level, and considering that boards are usually appointed, that we want to definitely include them. In terms of an overarching definition, perhaps we could say something where the interference of anyone in the execution of their duties. I think that covers all. When you say interfering or someone free in an environment to conduct their duties, I think the word duties covers all that we may want to consider. Just offering that suggestion.
Thank you. Thank you, Senator Longmore. SG?
Yes, thank you, Chair. So what I'm not clear on is if the catch-all is to deal with the situations contemplated, and when I mean the situations contemplated, the workplace, accommodations and institutions, or if the committee is looking at something else other than those three situations. Because that's not what I'm clear on when you say that things are not, if to cover, to do a catch-all, I would need to know to cover what exactly. Is it outside of employment, institutions and accommodation, or no?
Well, I don't think it would be outside of that, but Senator Scott Motley could expand on, what the question is.
I wasn't thinking of outside of those, but more the relationships and the circumstances. Because as I said, we had, in spite of the fact that we have spent a lot of time discussing these issues, we had not contemplated like the board member relationship. And I'm just wondering if there are other relationships which take place in a work environment, which we might need to address, but can't address because we have not specifically contemplated them. It was a thought which was going through my head as I was listening to everybody and listening to the decisiveness which accompanied the suggestion. The responses were very clear. So I was concerned to say, are there other things which if we had put to the committee, they would have been equally decisive about, but which we have not put to the committee? And how is it that we would be able to address these situations? So it was more out of concern. My own view, as you know, Solicitor General, has always been to try and make sure that the bill is very focused and very clear, because you want to achieve your objective in the sense of giving the best possible protection to persons who suffer from sexual harassment. And sometimes when you make it too expansive, you do lose the intention of the legislation. You can, rather than making it effective, you can create so many challenges around it that you lose what you were trying to do. And this is a context in which my hesitancy came. Now that I have been persuaded, I am concerned, and that is simply what I'm doing, sharing my concern and asking the experts if there's any way that it can be addressed.
Okay, so not an expert, but so my take on it is a part of the reason I was included in workout was this exact reason, which would allow for an expansion of what's already listed in A to H to allow for any other, and it says person of a class prescribed by the minister. Now perhaps we could look at I to see if it could be reworked to make sure that, because this is supposed to cover future expansion of the meaning of worker to address sexual harassment in the workplace. So my only response would be to review I with a view to seeing if it can be reworked, if it can be reworked to ensure that it would adequately address the issue that has been raised. Outside of I'm not sure what else we could do. This is, again, a sort of template we have taken from other jurisdictions. So that's the only reason I'm saying we could look back at I to see what was done elsewhere and see the wording and see if we would want to tweak this wording in any way to try and make it as expansive as possible.
Chair, if I may respond, I looked at I, and although it is wide, I did not believe that. I did believe that it was not sufficient. And so I am happy to hear you say that tweaking it and tightening it up would meet the objective, which I'm concerned about. Thank you.
Thank you. Mrs. Robinson, your hand is up.
Yes, Minister. I've listened, and I just wanted to not necessarily repeat everything that I've said, but I just wanted to mention that in terms of part 2, going back to part 2, where it speaks to the prevention of sexual harassment, it indicates that the employer has the duty to ensure that the environment is free of sexual harassment. And members who are board members are persons who are part of the work environment. In the same way that the employer is required to have a policy statement that would have emanated from the legislation itself to ensure that all persons who are related to the institution or the organization are covered so that there is no harassment that is done and there is no provision made for it. Because the idea of the bill or this act as it is to ensure that all persons who experience sexual harassment are covered or captured. So I agree with Sandra that we could tweak one part of the definition under worker to include board members and any other persons that would be within the remit of the work environment so that all persons are covered and captured. Thank you, Minister.
Thank you, Mr. Motley, I see your hand is still up.
No, Chair, sorry. I'm going to take it down immediately.
Mrs. Robinson, your hand is still up. So members, go ahead, Senator Gale.
Chair, I was just trying to clarify from the Solgen if tweaking I, because I seems to me, in my mind, to be futuristic in nature. And if we're going to be capturing what we have been discussing now, would it be that we would insert a new I that would take into consideration board members and amend and create a J that would speak of what is being submitted now as I?
Okay, so if I may, Chair.
Yes.
Yes, please do.
Thanks. Right, so I thought the committee had agreed that you would be inserting a paragraph to deal with board members. I thought that was already agreed.
No.
So
I would say, SG, that it is now.
Sorry, that what? Sorry?
I will say it is now agreed.
Oh, okay. Okay.
That was what I was seeking to clarify, Chair.
No, well, it's just that a majority of members had spoken in favor of it. So I would have thought just by sheer mathsing it out, I thought that there was already agreement. But okay, thanks, Chair, for clarifying. So right, so there would be a provision dealing with board members. And so I would probably now be J. I mean, the drafter would do that. And I was just saying, current I was supposed to be that futuristic, but just that there's no harm in us looking at it, comparing it with other catch-alls, just to see if it is as expansive as we believe it is, or to see if there is any kind of modification that can be made, not to limit it, but to make sure that it could cover what is being discussed, as in any other category that we think is not addressed right now. But I see Mrs. Celia Brown's hand up, and she's a drafter, well qualified to deal with this area, way better than I am.
Yes, thank you, SG. Go ahead, Mrs. Celia Brown.
Sorry, Chair. Chair, I'm trying. I'm not so sure about well qualified. But from my recollection of when we were drafting this legislation, Chair, I think the first draft would have spoken to employee and employer, and we would have taken it from the CARICOM model, which would have defined employee as apprentices, persons on probation, full-time and part-time employees, and commission agents. We then decided the definition of worker was then included as Jamaica's policy decision at that time. So I is very unique to Jamaica, and I contemplates the case where a minister has the power to add any type of worker that he or she may want to add, given having regard to whatever circumstances are at play at the time. It is my view, therefore, Chair, that I don't think we should, if we're going to include the board and the board members, I think we should do it as a separate provision in the bill, And I don't think we should touch the definition of worker or even interfere with paragraph I. So just like how we deal with sexual harassment of within institutions and accommodations and all of that, we can just do my suggestion would be to do a subpart of the provisions that deal with the employed at the workplace and put in specific definitions for the board members and the boards and for the chairpersons and board members. I've been looking, my research is not extensive because I've just been sitting here while we are meeting and I'm looking through, and I'm not seeing that construct in any other jurisdiction. But what I'm seeing, Chair, is that where there's some jurisdictions, for instance, Australia, which itemizes, for instance, that's why I was saying a while ago to Mrs. Aldred on the phone, when we start including, how far do we go? Do we include partnerships in firms? Do we include commissions and agents and that sort of thing? Because what I notice is that where there's a trend to list the different types of occupation in legislation, it goes very wide. It speaks of clubs, organizations, partnerships in firms, commissions and agents. It's a lot more extensive than how we have dealt with it here in the scheme of the bill, where we speak to workplace. So as I would reiterate, we don't touch the definition of worker, but we include a particular provision, if that's the way we're going, to deal with board members and chairpersons of board, and leave I as it is, because I is very futuristic and it gives the minister the power to include any other type of worker he or she may want to include in the future, should circumstances allow, provide for him to do that. That's just my view, Chair.
Thank you. I would like to hear Senator Gale and Minister Johnson-Smith's comment in relation to where we have reached with this discussion. Thank you, Mrs. Celia Brown.
You want to go to Minister Johnson-Smith first?
Well, that sounds more like a request for me to come in.
It was more a nudge, Minister.
Thank you. Not Senator. Madam Chair, I think we're clearly agreed that that they should be in, and I think the point made earlier that we will never be able to contemplate every person who should come in. I think the point had been made earlier that there should be some flexibility. But the fact is that I do believe that there is flexibility in the bill already, and that we do need to maintain the compass space of mind as well. So I have no difficulty taking guidance from the technical team. Should it be that we include specific reference to the board members, to board members for their, whether it is as that for the purposes of this act, they'll be considered a worker, or whether it is to have something standalone, which has broader flexibility. I am simply confirming my agreement with the recognition that we do believe that such persons should be included, and in principle, that the language needs to have some breadth, which it does. I'm hopeful that when we've seen the language regarding third parties as well, that will help. It may well be that the act in play, when considered by a court and its intent, and maybe the debate will have some impact on this, how it's interpreted. I'm not sure whether the court will be minded to give a broader interpretation of the definition of a worker and expand what it means to be under a contract for services, or whether it is that there will be other language considered when we see the words that are proposed for the third party claims, etc. That will give another leg on which a potential claimant uncontemplated by us around the table today, around the virtual table today, by which means their protection can be secured.
Thank you, Minister. We miss you.
So Mrs. Celia Brown had indicated that there's a harm in having this long, exhaustive list, because someone might ask, what about me? So I'm not encouraged in terms of going that particular route. My preference is to have one that speaks to board members because we have discussed it extensively for the scope of this particular legislation. Again, the definition of worker as it is now outlined in this piece of legislation can be replicated in other legislation. Save and except, I don't believe we should include the board member in the definition here because of the scope that is applicable for this particular legislation. So if the technical team can identify where else it can be inserted to make reference to board members, I would be comfortable with that. And certainly, I would like to see how we're going to treat the third party. But I believe that is one of the areas that the technical team had promised to come back to us with, if I can recall. Thanks, Chair.
Thank you, Senator Gale. So at this point, I will ask Ms. Grant to comment. I think you've pretty well gotten a sense of where we want to go.
Well, what I have here as a decision, Chair, and you can tell me if I'm correct, is that we're going to have a standalone clause that treats with harassment by a subordinate to an employer or supervisor in clause 7. And we would also want to include as in the definition, board harassment of board members, board member to board member harassment.
Board member to board member only?
Well, I think it's not so narrow, isn't it, that we want board members to be included, whether it's board member to employee or board member to board member or chairman to board member.
But the thing about board member to employee, which is what I took away from the discussion that was raised, is that in clause 3 as it is now, it would take care of a board member harassing an employee, in that the employer the duties imposed on the employer to make the environment free from sexual harassment, but that there was nothing specific that covered harassment between board members.
I think 3 speaks to a broad duty about the environment, but it is likely to be a matter related more to process. But I think section 4 is quite clear in terms of protecting certain categories, and 7 protecting particular categories. And so I just worry about relying on that alone. That's about the broad employer's duty, and that exists and should protect everyone. If we should be one leg of every claim, if the employer hasn't done what they should have done, notwithstanding the act of someone else in the work environment. But then there is the question about the act, the offense itself. So there's an offense of an employer failing in its duty to make a reasonable effort that their workers are not harassed. That's a broad employer's duty. But in terms of the act of harassment and who can undertake it, who can perpetrate it, that is a little different. I think I view the offenses as very different, and I'm not sure that.
If I could just interject, I think Mrs. Seeley Brown had come with another solution that I think would have satisfied the committee, which was to have a provision, a specific standalone provision dealing with the board members. And Mrs. Seeley Brown had suggested not interfering with the definition of worker, but instead putting in a standalone. And I would commend that position to the committee in light of the issues raised by the committee and the intention expressed by the majority of the committee members.
Chair, that deals with it, you know.
Great, great.
That really deals
It
with
would.
it. If it have that standalone clause, once you
Yes.
can see what it looks like, that deals with it.
All right, so I just wanted to make sure that I captured the committee's position, so that is clear.
Ms. Grant, just to make sure you have captured what is recommended by Mrs. Cedar Brown and that the committee is fully clear on what is being recommended here. So I don't know if you have, it's clear to you what is being proposed by Mrs. Cedar Brown.
It's clear to me, Minister, standalone clause.
All right, so go ahead now and state clear for the committee.
Minister, just for clarity for the report. Sorry.
All right, Ms. Grant, if you hold for 1 second, let me just take Ms. Daly's comments. Denise, go ahead. And then we'll come back.
So I just wanted to find out whether or not she was clear about the standalone or what we were trying to establish. But she make it quite clear that we want it to be standalone. I personally believe it should stand alone because they, in my view, even though they are workers, but they are classified as a different level of workers.
Okay, so Ms. Grant, could you now outline clearly?
I think Mrs. McCarthy was asking for some clarity for the report, Minister.
Yeah, what were you asking, Ms. McCarthy?
Just asking that Ms. Grant repeat the standalone, the details of the standalone provision for the report.
She's going to do now, so
yes,
that's clear to all of us.
Okay, so the standalone provision would include board members, harassment between board members and employees, and harassment between board members and board members. Yes, that's what the standalone clause would address. Yes, I captured it correctly. We're just dealing with the board members and their harassment between employees and each other.
In my mind, yes.
Okay. And what I have as well, the general consensus, what I gathered is that there's no establishing of a cap for the award, and the I is going to be left alone, so the definition will remain as is. The definition for worker, I will remain, and that the proposal to court, which was suggested to mean the Supreme Court, that as opposed to the parish court, that remains unchanged.
Okay, is there anything else that needed further clarification? I think we're all, it's now very clear to us. And Minister Johnson-Smith, you're fine?
I am, Madam Chair.
Okay, Senator Gale, members, you're fine. Okay.
I'm good, Chair.
All right, good. So we can go on now, Ms. Grant.
Yes, Minister. Continuing on, Jamaica, well, I had said this, mandate public education around sexual harassment in multiple spaces. And this is something that we have, well, the members have always been in agreement with, that we need to mandate public education around sexual harassment in multiple spaces. Matrix 2, these are some provisions that JFJ made. They ask that some consideration be given to how concurrent matters are going to be addressed under this legislation, specifically where a matter that is rightly placed in the Industrial Disputes Tribunal, but it has some element of sexual harassment, that the legislation consider the overlap or the possible concurrent jurisdiction that these two are to have. How is it going to be treated that when the sexual harassment matter comes before we do with the IDT matter, or do we put this on hold, or vice versa? They also indicated that we consider inserting a provision which requires each member of the sexual harassment tribunal to undergo mandatory training prior to assuming his or her role on the tribunal, and also that we insert a provision that the tribunal will have a secretariat and that the secretariat should be housed in a location or agency that allows it to act in an independent and impartial manner. And let me just read the last general recommendation on the Matrix 2. This is from Awoja, and they recommended that compensation be provided for the provision of therapeutic support to be paid by the offending party once that party has been found liable on behalf of the victim.
Okay, let's take them one by one. Senator Natalie Rodriguez, I see your hand up.
Thank you, Madam Chair. The recommendations that were just read through, the Jamaican State Justice one about the mandatory training for members of the tribunal, I want to just say I strongly support that. I think it will go a far way in getting the work done. But I had originally placed my hand up because I know I was absent from one meeting, so maybe it happened then. The general recommendation that was on Matrix 1, I noticed to reach Matrix 2, but there were two others on one that there's one other one from Women's Empowerment for Change on Matrix 1. So I'm not sure if we were planning to go back to Matrix 1 or it was an oversight, because I have a note here that their two recommendations were the team was supposed to word something and get back to us on those two. So I'm just.
Okay, Ms.
Senator, what are those? I'm not hearing you, on mute.
On Matrix 1, because I noticed we have moved on to Matrix 2. On Matrix 1, Women's Empowerment for Change, there was at the bottom, the state must also consider that the workplace is the 21st century. Yes. I have a note here that the team will get back to us on that issue. So would love to know if I probably missed when the team got back to us on that. And also the first recommendation to criminalize street harassment. I have a note here that we're not accepting it, but if it happens between a landlord and a tenant, for example, on the street, how it would be treated, I have here a note that it will be worded and brought to us for consideration. Because we had a lengthy discussion to say we can't take on issues of street harassment, but if a manager and staff and it happens on the road, or a landlord and tenant and it happens on the road, and it was that the team would word something and get back to us on it.
I don't recall that last point about the specific to the landlord and tenant. That I don't recall. I recall us being the discussion being quite robust as it relates to street harassment, and as you rightly said, the decision was ultimately this legislation cannot cater for it. It would be rightly placed in another legislation. As it relates to We Change, I have it here on the Matrix 1. I omitted it because we had discussed it in earlier meetings. The thing about the workplace, the essence of their recommendation was that the workplace should not be confined to walls because it has moved outside of that now really in the 21st century. And we have been at pains in discussing that throughout our meetings to say that the workplace, it's not defined in the legislation actually what a workplace is. And so that's why I did not mention it, because it's not defined. And because it's not defined, it is broad enough to take into consideration where the workplace is, whether you're working online from home or so on. So that's why I didn't mention.
But can I then, raise the issue, what happens if a landlord and tenant, for example, are on the street and there is some sexual harassment that takes place? It's not in the context of the residential building or anything, or colleagues at work, because we did have an extensive conversation, but I don't think we reached a conclusion. As I said, my notes say that it would have been worded and brought to us, but I don't know if anyone else was in that discussion. remembers what happens in those scenarios, because we didn't reach a conclusion.
I see Senator Longmore's hand up and MP Daly. Go ahead, Senator Longmore. Maybe they wish to comment on the point raised by Senator Campbell Rodriguez. Senator Longmore? MP Daly, please go ahead. Okay, I'm not hearing them.
Yes, Minister.
Yes, go ahead. Go ahead.
Yes, I'm very concerned, not little, in respect to the landlord and tenant, especially if it is not done in the confines of the dwelling, because I've had complaints coming to me personally in respect to that level of harassment, but they would tell you that it is not done at home. It is more in public space. So, I really would love to get some clarity and to find out how best we will be able to involve it in the act, so that we will be able to capture those concerns that the women more so have.
Thank you, MP Daly. I see Simon, Erica Simon, Legal Reform. Please go ahead.
Yes, I had just wanted to say that based on the concerns that were raised, as far as I understand the bill, once what has occurred falls within the circumstances in the bill, it doesn't matter the location. So that was why the definition was not included as to workplace or anything like that. So, and the same thing for the landlord and tenant. Once one of the circumstances identified in clause 9 occurs, the location to me is irrelevant.
Okay, thank you. So that would answer your question, Senator. I will go to and then MP Brownberg.
Sorry, who did you say, Chair?
You had your hand up earlier.
Oh, it was in the same, Mrs. Simon had answered, because in my mind, anyway, once there's a relationship between tenant and landlord, it is irrelevant as to where it takes place. It could take place under the tree next door.
Okay, thank you. Thank you, Senator Gale. Senator Longmore? You there?
Yeah. Yes, Chair. Thank you. Chair, I'm wondering around the decision or the communication that the cases of public harassment. We're dealing with a very significant piece of legislation, especially to the culture of interaction in Jamaica, Minister. And so I know that one of the main things that the woman on the road, and I won't say the man, one of the main things that the woman on the road has as a concern is being harassed when she is being transported. And transportation is work. So whilst I recognize that we may legislatively refer it to another piece of legislation, could I be directed as to which piece of legislation that would apply? And also, if I am thinking that one of the reasons to do this is because of maybe the burden of proof. The burden of proof to prove that in that public space this occurred. In our technology-driven world now, and even maybe this is emerging maybe with the Cybercrimes Act. If a young lady knows that when she goes on a bus, the driver or the bus conductor is going to act a certain way towards her. If she can arrange with a friend or a parent or somebody to record this, why maybe we could look to allowing once the burden of proof is able to be met, especially with technology and the use of the technology to help protect the vulnerable, perhaps we should consider looking at that provision. And if not, I would love to be directed as to which other legal legislation would be the one that applies. Because the way I see it is that work environment, when you're on a bus, so a lot of persons who take the public transport is because of work, is because of the pursuit of their occupation. And it is a significant thing that I think that a lot of persons are concerned about in the society, and one of the ways that we can start enabling the public protection. So just offering that and asking regarding which legislation would apply in that case, or where's the direction to develop it. Thank you, Chair.
Thank you, Senator Longmore. I don't know if anyone of the members of the technical team would wish to respond, but I know this has been raised before, and I also understand that other pieces of legislation are being worked on, including stalking. I don't know if anyone from legal reform or any of the other entities would wish to respond.
While they're preparing to respond, Minister.
As far as I am aware, nothing is being done for street harassment, but something would have to be done separately. The legislation I've seen so far that deals with street harassment is criminal, and this legislation is more civil, so it would require something separate to be done. I don't think anything is being contemplated for it, so I think something separate would have to be commenced.
Chair, if I may, through you, Chair.
Senator Longmore,
yeah.
Just ask Mrs. Simon if they are contemplating developing legislation regarding stalking, because I think that was said before by a representative from the team that was contemplated or was in the works.
As to stalking, I think a colleague is working on an opinion on it, but I'm not sure that it's at the point of legislation. I know that a colleague is working on a proposal on an opinion for our department on it.
That's
as much as I know.
Yeah, I'm not suggesting that legislation is far advanced, but I know that they were when street harassment came up. I know that was one of the responses.
Yes, stalking is being an opinion.
All right, thank you, Mr. Simon. Yes,
but Chair, if I may.
Chair, Madam Chair.
Sorry, just to clarify and just to kind of specify, it's not, I don't want to totally expand to street. I was thinking because we can maybe start in the transportation sector that is still public, but we may be able to better apply. Thank you, Chair. Thank you, MP Brownberg.
Yes, go ahead.
No problem. But Madam Chair, you know my position on street harassment. I have not been able to articulate it. I have given up any thought of it being included in this bill because I know where we are headed. But I just would not want this session to end without placing on record my opinion that the majority of instances where women are harassed, sexually harassed, really takes place in the streets, and that we need to find protection for those individuals, or men or women, but our men as well, who are harassed sexually on our public thoroughfare and in the public domain, and not as restricted as this bill is. And don't get me wrong, I recognize the bill that we're working on as a seminal piece of legislation that is important, long overdue. People are waiting on it, and I know we have put everything into it. I still feel that something we have missed that opportunity. I'm not fighting for it. I understand what we have agreed on, and I'm okay, but I believe that we need to make, and certainly I'm making a commitment that we, the lawmakers, legislators of the Jamaican Parliament, need to look at giving our people, our women in particular, and those men, the protection on the streets that they deserve. And thank you, Chair, for allowing me to reiterate my position on this matter at this time.
Thank you, MP Brownburn. We all agree that that's an area that has to be looked at, and that is of great concern. You know, I have a saying, and others do have that saying too, we're eating this elephant a bite at a time. MP Daly, you wanted to make a comment?
Yes, just quickly, Madam Chair, because I would be very uncomfortable not saying exactly where my headspace is right now in respect to education, public education. Let me tell you something, Minister. I don't think we are sitting here and putting all of this together to ensure it is really a radical piece of legislation that is going to take effect, because the way in which we were culturalized, especially our men, it is going to be very important that equally we start the process of education in terms of going in the school, because a lot of even some of the pregnancy that started in the school, it started into the bathroom, it started with the young men. Some of them is just about 2 years older than the person who they are in relationship with. And they will tell you, when I used to be at the juvenile board, they don't believe it, nothing was wrong. And it is going to be unfair for us to sit here and put together something that is going to protect all of us, the women and the men, but at the same time, they are not aware of what it is that they will be charged for. And I strongly believe that we are not doing enough to publicly educate. Every day that I go out and speak to them about when that bill or when that law comes out, this is going to happen. They say, really? They don't even know that something radical is happening in terms of how they behave, and therefore we need to prepare them for it. Thank you.
Thank you, MP Daly. You are so correct. And we recognize that it's of extreme importance, and we will be getting the funding to ensure that we can do a massive public education program to support this piece of legislation, and also to educate the public in terms of gender-based violence and the work of CISOCA. So we are moving on those things. Senator Longmore? We're not hearing you.
Sorry, pardon me. I'm trying to figure how we maybe could come up with a situation that helps to address the impasse with the public space and protection in the public space. And again, like I said, maybe I'm hoping to be guided by the legal team in terms of the link with the cyber crimes. But in terms of the definition of work, if work could be expanded to include the conveyance to work. So let's say someone who transports for work can prove, so they have an employment record, a pay slip, or if it's a student, a registration with school. And like I said, they're able to prove in those, if we're able, because I think that is maybe just to expand work to include access or conveyance to work. If that could maybe be able to offer some level of protection in the public, and it's a start, because it's a monster to do it in the street setting. You know, it is really a daunting task how to, and we don't want to lose the bite, I think, of the law also. So I think maybe if we could consider where legislatively we can include the conveyance to work. So in the taxis, in the buses, And that might start the ripple. Thank you, Chair.
Suggesting on public transportation as opposed to street harassment on.
I'm proposing that we start with dealing with street harassment in the public transportation or the conveyance to work. And those instances can be proved or proven by the presence of a record of work or enrollment in a conveyance to work. However, you know, that's basically easy. And then you can have evidence proof of that being submitted, whether through whatever proof, technologically driven proof can be accommodated, which I'm thinking in cybercrimes, etc. So, and that I think would start and give a message, especially for this piece of legislation, that a lot of people are paying attention. We just mentioned, and MP Daly mentioned around the public relations and platform of, we also, I put it to you, how many of us are presently sharing what we are doing right now, here in this meeting now, on all our social media platforms, are actually demonstrating that we are in this forum discussing this issue. This is where it starts, huh? It starts with us too. So maybe we could offer that that idea out there. But it is, for me, wondering about expanding the definition of work to include the transportation to and from there. Thank you, Chair.
Thank you, Senator Longmore. I will take Ms. Grant.
Yeah, thank you so much, Chair. I just wanted to comment on a few things that I have been hearing. I don't want us to conflate a lot of the issues and some of the things that I have heard. So for example, when MP Daly spoke about the whole issue of pregnancy and what happens with the young people in the bathrooms and equating it to public education, which is important with specific reference to this legislation, but just to say that whatever arises out of such a situation is not something that would fall under another piece of legislation, right? But the public education aspect is certainly something that we have been in agreement with, at least since the very start of our meetings, that we need to do public education around this. And I don't think the position has changed. As it relates to what Senator Longmore said about the conveyance to work, the buses and the taxi, the transportation system, while I understand the concern, Chair, but this legislation, or I will start from this point. The research that I have done so far as it relates to any form of street harassment or any action that is meted out to a person in a public space is something that is dealt with criminally. This is a civil legislation. This legislation is dealt with it's a civil piece of legislation. And something as street harassment or any sort of behavior that is injurious or harmful to somebody that occurs in a public space is something that, and I recall us agreeing in previous meetings, that it needs to be dealt with criminally, and so in another piece of legislation. To try to insert something in this legislation, hoping that it will bleed over or take root in another legislation, is, to my mind, the mixture. I would not recommend that mixture, because, and this is something that we had said before in other meetings, that how do you, well, it's not even about proof, but how do you really tie something like that down? All right, so you use technology and all of this. The essence of what I'm really saying, Chair, is this, that cyber crimes, it's a criminal piece of legislation. This legislation is civil, and any other harassment or any injurious or harmful conduct, degrading or otherwise, to another individual that occurs outside of the ambit of what we are seeking to protect here in workplaces, in accommodations or institutions, really deserves special treatment and needs to be dealt with in another legislation, Chair. And I really wouldn't want us to conflate the issues.
Thank you, Ms. Grant. I will recognize Senator Gale, then Senator Longmore, and MP Bailey. Go ahead, Senator Gale.
Chair, those matters as represented by both Member Daly and Senator Longmore have been matters that have been raised already during the course of these deliberations. Again, this is a civil legislation. The scope of it is very clear. Those who are going to be held accountable for their actions, it is very clear. Where it is going to be placed in terms of a tribunal is very clear. And I believe we had agreed that the report would make reference to these other occurrences that are outside of the scope of this legislation and encourage that other legislation make provisions to treat with it. What I don't want us to do is to, whilst we understand and accept that there are concerns being raised, if we continue to make moving targets, we're going to stretch the scope of this legislation and we might not be able to conclude it in any time soon, because I can understand the challenge that the technical team would have in making not only amendments, but also the policy direction that this legislation would take.
Thank you.
Thanks, Chair.
Thank you, Senator Gale. Senator Longmore and MP Daly, your comments, please go ahead in that order.
Thank you, Chair. Okay, so my question that I asked and was more also to recognize solutions possibly for this problem that clearly exists. And I appreciate the input and the guidance. I would love to just be directed as to which other legislation would apply, because I think, especially for the persons who have this similar concern to address this issue in this way, like myself, I would then know to constantly hear that it will be, or it is to be dealt with in other legislation. At least give me an idea as to specifically which legislation, and ensure that within this act that may be referred to in some way. Or in the public education aspect of it, we're all about public education, ensure that that circumstance is specifically addressed in the public education, that because this is of a big concern to persons who deal with this daily. I am wondering, in terms of this being, and maybe it could also be considered a deterrent if sexual harassment, whatever level, mild, in whatever age group that may occur, carries immediately a criminal response, it could deter the reporting of it in the streets. The thing is, you can imagine the man rob up a woman and him get 3 years in a prison. Yeah. So I think possibly as we evolve with and yes, I may be questioning the tenets of legal bases and such, but in my mind, there might, if there isn't a provision, and maybe this is for the review process that we have in developing these new legislations. And maybe what I'm thinking is maybe we could look out for this effect, because we have a review process, and maybe I'm suggesting for future reference. But I think it is critical that we recognize that there might need to be a hybrid situation. And maybe, as I said, in the Cyber Crimes Act, we can look at that in terms of the burden of proof and being able to accommodate such.
Senator
Thank you, Chair.
Thank you. But I think the example you used must be covered under some existing legislation where a man rub up on a woman.
Yeah, I got that.
No,
Yeah.
that would be
Well, yes.
Yes. So chair, perhaps maybe what I'm hoping that we can address in terms of the public education program and the content thereof, that aspect of it be very, very emphasized, because persons would want to know, where and how to refer such situations.
Well, Senator Longmore, that's in our hands. And you as a member of the Gender Advisory Council, you know, would play an important role in terms of a rollout of a public education program.
Yeah.
So your role is critical there. Minister Johnson Smith.
Thank you, Chair.
Thank you, Chair. I was just going to clarify, given the points just made, that certainly if somebody rub upon you and it is not wanted, that is assault and it's already covered. It's already under the Offences Against the Persons Act. It's already a common law offense. And I think the difficulty that most women experience is that the issue is not always physical. It is the calling, the following, the stalking, the discomfort, and as well as the physical, yes, but it is the gap in the law is the offense of stalking doesn't exist, criminal harassment doesn't exist. And that is being recommended for inclusion at this point in the Offences Against Persons Act. And I believe that there is even draft amendments already proposed. That is part of the amendments that are proposed coming out of the Joint Select Committee. So the committee had agreed that it should go in the Offences Against the Persons Act so that the Cybercrimes Act will incorporate it where done by technology, because remember, that's how the scheme of that act goes. It allows a criminal act perpetrated in actuality or person to person to be conducted by virtual or virtual means. So I just want to support as well, Chair, the call for a comprehensive public education program, which maybe need not only be grounded in the act when it is completed, but that the concepts of harassment, the negative, the way in which people perceive, women in particular perceive and receive catcalling and harassment. There are examples in the papers all the time, and it has been publicly spoken about. And it's a deep concern, I know, for every member of this committee. The issue is, however, ensuring that we don't so stretch the parameters of this act to breaking point so that we end up in what could be groundbreaking legislation that actually changes the work environment for women as a whole. Yes, for men as well, but as we all know, statistically, it is women who experience harassment more. So pardon me if I use us as our point of reference. And that we ensure that that while being creative and expansive in our thinking, that we ensure that the steps that we take and the recommendations are those which can be implemented effectively. So what can be dealt with by communication doesn't need, I think, and I'm glad you have mentioned the Gender Advisory Council as well. Perhaps recommendations need to be made about the public education that should be ongoing even now as the committee is meeting, about the concepts and how it is that these things are wrong, as well as recommendations for inclusion in school curricula, whether it is part of the HFLE curricula or it is otherwise, but another way of ensuring that it is a message that's getting to our boys and girls at those formative years when they, of course, are going through puberty, etc., and learning about appropriate relations between the sexes. So I just wanted to remind that it's the Offences Against the Persons Act that is now being looked at, and there are draft amendments that have been prepared, and that, I don't know, I think there's some standing order that says that a Joint Select Committee on one matter can't consider a matter being, that's before another committee, but just to mention it and to indicate that it is a very real work in progress by the being led by the Ministry of Justice, and that I'm sure we will have an update in short order. Thank you.
Thank you, Minister Johnson Smith. There will be an update shortly from the Minister of Justice in relation to the amendments that he is responsible for, and from my end on the amendments regarding the Domestic Violence Act. But we do need an overall program relating to gender matters affecting women and children primarily, but of course, it would also have some impact on our men. And so these are areas that we are looking at and that we are moving speedily to address. Senator Longmore, I see your hand up. We're going to be wrapping up this session shortly. We have to end in time for another committee to meet. We're going to have to set another date. We are on the wire now. We have to have our report ready in a matter of days. And so we will have to try to find another day this week, if possible, to meet, or early next week. Senator Longmore, go ahead. Thank you.
Thank you, Chair. Thank you. I appreciate it. And I appreciate the references to the legislation that applies. Just to say that I have to do this because of the
Sorry, Senator, not to disrupt your flow, but it doesn't apply yet. It will apply, but it doesn't. There is a gap in the law, but it will. I just want us to be clear, because as you say, people are paying attention, and I don't want these things to be misreported either.
Thank you. So, of course. And no, it's not. I'm fully resolved on that matter. I'm just glad that the reference is made to the specific legislations that are being developed.
Moment, Senator Johnson Smith, could you put your camera on, please, as we come to the end of the meeting? So if you have another comment, we'll see you on camera. Very good, excellent. Go ahead, Senator Longmore. I'd ask members who can put their cameras on, if you could please do so. You're on PBCJ Live.
Fantastic. We need to start sharing this ourselves. I just quickly want to say, Chair,
public that you're not just voices, but your faces. You know, put a voice to the face. Go ahead, Senator Longmore.
The offense of sexual harassment is a bit lessened than sexual assault, etc., etc. In the public space, just to consider where we develop our laws based on the fact that the criminal offense for something that could be not as egregious, these persons who offend seriously start somewhere. And if we can intervene to restrict and limit that beginning, it won't reach the extreme cases of assault. And I just want to point that out. So thank you, Chair. Thank you.
Thank you, Senator Longmore. And so we are to end our committee meeting at midday. It is now midday. I just want to indicate that we can't make that decision at this moment, but you will be contacted regarding our next meeting, which has to be very soon, because we urgently have to table the report in this month, and to ensure that the legislation is passed during this quarter. We have some outstanding decisions that we're going to have to review at our next meeting, and we also have to complete the review on the matrix of submissions on the general recommendations. Ms. Grant, is there anything you want to say just before we wrap up?
Sorry, Chair, I'm not Ms. Grant. Sorry to interject, but just to remind, just to remind that the AG's chambers had some matters we wanted to report on as well. So
let's do that before we close off.
You can take us? Okay, so I'm gonna ask Miss Shelley Ann Thompson to just to take us through. She's a Crown Counsel in the chambers.
Thanks.
Shelley Ann, over to you.
Thank you, SG. Good afternoon, Madam Chairman, the members of the committee and my colleagues. The committee had asked us a few weeks ago to do some research and to revert to them on a few matters. The first of those matters is whether or not employment or re-employment is an appropriate remedy. And this issue arose by virtue of clause 34, 1B3 of the current draft bill. And based on our research, what we were seeing is that we were able to identify provisions in legislation in both St. Lucia and Guyana, which permit re-employment or employment of the complainant. However, and I'll just start by saying, let me just pause a bit to say that sexual harassment is treated in St. Lucia as a criminal offense. Be that as it may, the legislation does provide at Section 24 of the Equality of Opportunity and Treatment in Employment and Occupation Act that the court, and this is something which goes before a court, the court may, pursuant to Section 24 of the Act and on an application made by the complainant, order that the employer or relevant person makes amends by employing, re-employing, or reinstating the person who was sexually harassed, as the case may be. And an important point that should be noted is that specifically in Section 24B of that legislation, this applies regardless of whether or not the employer had filled that position already. So what it means is that an order can be made by the court for employment or re-employment or reinstatement, notwithstanding that the employer would have gone ahead to employ someone else in that position already. So that is something that the committee may want to consider whether or not that is something that they would be minded to do. We also have Guyana, which speaks to reinstatement of the individual. And that provision, particularly Section 26 of the Prevention of Discrimination Act 1997, provides that a party may apply to the court. One moment, please. That the party may apply to the court, and they may seek an order directing the employer to redress the contravention, including an order that the employer and the aggrieved person, if they so agree, that the person be reinstated. So those are two. The committee, what we'd like to bring to the attention of the committee specifically is the fact that with respect to the St. Lucia provisions, it's a stricter type of provision as opposed to Guyana, which provides that the reinstatement would occur if parties agree to it. The next issue that the committee had asked us to consider was whether there are any provisions or penalties for the making of a false complaint, which is similar to what we have provided for in Section 39(2) of the Sexual Harassment Bill. And what we have found is that there are some provisions of a similar nature in, for instance, the Integrity Commission Act here in Jamaica, particularly Section 37(4), which provides that a person who, whether orally or in writing, makes a complaint or gives information or notifies the commission about any matter, knowing that to be false or misleading or reckless as to whether it is in fact false or misleading, that person would have committed an offense and would therefore be liable on summary conviction in the parish court to a fine not exceeding $1 million or to imprisonment for a period not exceeding 1 year. And we'd like to note at this interval that it is the penalty for the purposes for which we understand the committee to have sought our advice. That was in relation to the quantum of the penalty or the fine that is imposed. And this is in similar terms to what is currently provided in clause 39(2), which is a fine of $1 million. The committee may also wish to consider the Jamaica Nationality Act. This provision, however, whilst it does take into consideration a statement which a person makes knowing it to be false in a material particular or reckless as to whether that statement is false, the scheme here is a little bit different in that it only provides for imprisonment with or without hard labor for a term not exceeding 3 months. So those, and the committee would of course, need to consider where they would like to go in terms of that issue and how they want to address it, whether what is provided now is sufficient. Those are our findings in respect of those two issues. And I hope that's of some assistance to the committee.
Thank you so much. Thank you so much, Ms. Thompson. At this point, I will not invite comments since we're going to be wrapping up shortly, but just to really indicate that at the next meeting, we will have to consider and make our decision based on the information that is provided at this time. I think, Ms. McCarthy, is there anything else that I need to mention at this time, or we will just resume our discussions at the next meeting?
No, Chair. Everything that you've indicated already is already what you should have.
So we'll do the next meeting. You have any suggested times?
Based on the schedule for April, we're almost out of dates. I've been looking at them right now. I'm not sure if the PAAC will be held next week at this time, so we can't put ourselves in that space as yet. I'm only seeing currently for this week, Friday, if it is that the Senate will not be held. Friday is clear. Next week we have double meetings, but with that, I'd have to also check whether or not members clash with the joint select committees that are scheduled for next week. That would prevent us from meeting. That's one of the factors that would prevent us from meeting also at the same time.
Okay.
And Minister, we have a joint select on NIDS on Friday morning.
Oh.
So Ms. McCarthy can take note of that too.
Yes, I was going to say, although there will be no Senate sitting, there will be a NIDS meeting, so it's already taken.
Well, Minister, I figured that if Minister Chuck said it, he must have consulted with you.
Just about Friday.
He's quick on the draw, Minister. He's quick on
Not
the draw.
available.
I was wondering if it was a conspiracy.
No, but seriously, we have a deadline. It's very, very tight now. So
Chair, what about possibly on the weekend? If we can crunch in some time, I mean, I'm willing to give some hours on the weekend.
We could always lock down on the weekend.
Yes, it's a lockdown. Let's make it a working lockdown.
Yes. Let's ask Miss McCarthy if the team would be available, because we always have to take into consideration the technical.
I'm not certain. I'd have to send an email for persons to indicate their availability. I'm not certain.
And also for our legal teams, I know that there is one lady in particular who normally is not available on a Saturday. But we're gonna have to try to, but let's not solve it on air. We will work it out and we will be in touch. But we are really gonna have to now utilize the time that's left. So we must table this report in 2 weeks. That's our deadline. And the draft, the coordinator started putting together the draft, but we still have some unsettled areas, some unresolved issues that as a committee, we have to make a decision on. And so I don't know if we may have to caucus outside of the formal meeting in order to, so when we do have our meeting, we can be very specific in our decision. But that's something we'll have to look at. But we must table this report in about 2 weeks. Sectoral debate begins next week, Tuesday, the 13th. And every Tuesday and Wednesday, Parliament will meet for debate. So we have a full program going forward, but this particular piece of legislation cannot be left behind. And I really want to commend members of the committee and the technical teams and so on, that you have been fantastic. This is one committee where I would say most occasions we have almost 100% attendance and full participation. So I really want to thank you all. We all consider this a serious piece of legislation. And I know we're all committed to ensuring that we meet our deadlines. Senator Campbell Rodriguez, you wanted to make a comment?
Yes, just quickly, thank you, Madam Chair. Just to say that Saturday may be for some persons because of the vaccination blitz that's going to be rolled out by the Ministry of Health. So for example, I wouldn't be available Saturday, and I suspect some of the MPs will be getting their notices as well. So Saturday would not be a good day.
All right, we will work it out and we will be in touch. I don't know if there are folks here who mind working in the evenings. You know, we could spend a little time in the evening. But we'll work it out. We'll be in touch with you. And I really want to, again, commend you and thank you for your commitment and the passion with which you have been able to contribute to this piece of legislation. I see Rhoda wanted to make a comment. We're not hearing you, Rhoda.
I was just saying that I'm available on the weekend, either Saturday or Sunday, so I'll await the email.
Okay, thank you. Okay, so we will be in touch with you directly to see how we can, I do not want to go with, the quorum, it's fine, but I would want to have as wide a participation of members as possible, because that is how we have been working. Okay, so we will be in touch. Thank you so much. God bless you all. Be safe. Take care. All right.
Take care, Minister. Be safe, everyone. Bye.
Oh,
Bye, Minister.
Didn't say a word.
I had an issue, Minister, in getting on earlier, but I was rescued by Minister Johnson Smith. So I'm grateful for her assistance. But I've been following the proceeding from the beginning on PBCJ. So I have not missed anything, Minister. I'm here.
I'm so happy. This committee is one, there is no divide, and that's wonderful. Neither gender nor political, and that's wonderful. Thank you so much. Bless you all. Thanks.
Bye.
Bye.